It's Thursday and we're supposed to... Thursday and we're supposed to do the Thursday law vlog, except you can't go to daycare today because you barfed, right?
No.
Anyhow, he's sick, so today we're still doing the law vlog. You're just going to be in it. It is on copyright and some interesting lawsuits that are new in the news. Ow, ow, ow. You can't hurt stone. Oh, hey, how you doing? For those of you who don't know, there's an interesting lawsuit that just got started recently. This lawsuit was filed against a YouTube channel called Most Amazing Top 10. They have something like 3.8 million subscribers. The channel does top 10 compilations. In the compilations, they use various images, and apparently they're being sued by the copyright owner to an image of an ant that they used in one of their videos. If I believe everything I read in the blog that was written by the apparent copyright holder, Most Amazing Top 10 made a video and they used a couple of images of ants. Most Amazing Top 10 got hit with a copy strike because the copyright was claimed. In response, they filed a counter notice to the copy strike saying that they had been authorized to use the images. The copyright owner told them to take it down. They said, no, the best we can do is give you credit in the links. The copyright owner said, no, the best you can do is license the video for commercial purposes as you should have in the first place. And they ended up getting slapped with what seems to be $1 million+ lawsuit in the state of California for copyright infringement. Like I always say, there are legal aspects to these types of fights and there are human aspects. This one displays a number of those elements on both fronts. We'll get into it. All right, we haven't even been walking for 7 minutes. Sleep. This is gonna make the rest of the vlog much, much easier. All right, let's just start with the first and most annoying line that we hear a lot as creators, the quote, "Don't worry, we'll give you credit for it. It's my creation. I don't need you to give me credit for it. It's already mine." I mean, what's your credit gonna be? After you put it on your website, make money off of it, build your own brand off of it, you're gonna give me credit so that other people know where to go to get the original so they can steal it, make money off it, and build their own brand off of it? That's not how credit works. The other line you get a lot of is, I have 4 million subscribers, so you're gonna get a lot of exposure. Some people see exposure like it's some form of currency. Exposure is like being on Everest and not having a tent. Exposure kills people. It doesn't cause them to thrive. What most people don't appreciate is that the quote, "Don't worry, I'll give you credit" line is the exact same thing as going into a coffee shop, taking a cup of coffee out without paying for it and saying, "Don't worry, I'll tell everyone on the street where I got it." May I have a cappuccino? Yeah. Go, please. He's still sleeping. The other thing is that people tend to view the internet and what's on the internet as though it's not a real tangible asset. They seem to think that if you can find something on Google, it's somehow automatically de facto part of the public domain. It's not because you find something on the internet that it belongs to everyone for their free, unfettered use. Coffee is delicious. The other thing about the internet is that people think that someone threatening you from halfway across the world can't do anything about it. Even if the courts of California don't have jurisdiction, guess what? That's an argument that you have to make before the courts of California. The courts can raise the absence of jurisdiction on their own or of their own volition, but generally speaking, the absence of jurisdiction is something that you have to raise before the court so that it then declines its jurisdiction. But in order to do that, you gotta be in California or hire a lawyer in California, even if you live in Canada. People suffer from a lot of misconceptions about the internet, public domain and things like that. I think the tendency is to think that because something's on the internet, it's intangible, nobody owns it, it's for everybody. Something is not part of the public domain, meaning everybody can use it just because you can find it on the internet. It's not part of the public domain. It's not part of the public domain just because you can download the image off somebody's website. It's not part of the public domain just because it doesn't have a watermark. Public domain has a specific meaning. It refers to something that no longer benefits from any sort of copyright protection due to age or having been released deliberately to the public domain, or things that were specifically made for the public domain. For example, the sound effects and jingles on iMovie. Nobody can claim copyright on that because by their nature, they are intended for the public domain. All right, now is the part of the video where I tell you that nothing in this video constitutes legal advice, period, without exception, without caveat, without qualification.
Nothing in this video constitutes legal advice.
These types of issues are necessarily jurisdiction dependent, applicable law dependent, and fact dependent. They're almost always decided on a case-by-case basis. These are the broadest of broad brushstrokes. This is also the part of the video where I tell you that if you like this stuff, like, share, subscribe, hit the notification bell, tell your friends, family, parents, grandparents, spread the word. Knowledge is power. Now, back to the law vlog. Copyright. It's a word we're very much used to. Stop for 1 second and think about what the word means. Copyright. It literally means the right to copy something. The creator of an original work has protection over it, and unless you have the right to copy it, that creator benefits from copyright protection. It's really amazing when you think about it. We've gotten so used to the word, most of us probably don't even appreciate that that's what it means in its most literal form. Copyright exists. The duration of the protection will vary by jurisdiction. The penalties for breach will vary by jurisdiction. The statutory exceptions to copyright, meaning the ones that are codified in the law, will vary by jurisdiction. There are statutory exceptions, like making a photocopy of a book that you purchased, like reselling a book or a CD that you purchased. You can sell a CD that you purchased legally without violating copyright. You can't make copies of that original purchase and sell those copies because that would breach copyright. Oh geez, the kid has awoken. Good nap? Do you have any idea where we are? That said, the most famous exception to copyright protection, the one that everybody knows about, the one that everybody uses as though it always applies to their potential breach of copyright, is fair use. Fair use has 4 general categories, but by definition it is determined on a case-by-case basis. The most important thing to know about the fair use defense is that it is an affirmative defense, meaning it's up to the alleged breacher to prove fair use as a defense. It does not exist as a presumption of a defense to begin with. This is what a lot of people don't appreciate. They think fair use, so you can't come after me. Wrong. Someone can come after you, and it can in fact be fair use, but that's something that you have to prove to a judge. It's not fair use until a judge says it is. The first thing that the judges are going to look at under the fair use doctrine is the purpose of the use. Educational, non-profit, or commercial. If the use is commercial use, the judges are going to be much stricter on whether or not it constitutes fair use. If you're trying to make money off of it, it may be educational, but that is no longer the essential use of the copyrighted work. What do you say? Yeah. So the purpose of the use, educational, not-for-profit, there's going to be more leeway for fair use. Commercial, there will be less leeway for fair use, and it makes total sense. Why should someone be able to commercialize off another person's original work? They shouldn't. Another thing that the courts are going to consider when determining if something is fair use is whether or not it's transformative in nature. Take, for example, every Shmoyoho Songify song. They are working with works that don't belong to them, but their product is so transformative in nature that it constitutes fair use. And this is where some YouTubers like PewDiePie get into trouble because they think that reviews or reaction videos are transformative in nature to a sufficient degree that it constitutes fair use. The reality is, sitting there and replaying an entire video so that you can react to it is not necessarily sufficiently transformative to constitute fair use. So in determining if something constitutes or qualifies as fair use, judges are going to look at whether or not it is sufficiently transformative in nature or whether it constitutes parody, because parody is one of the quintessential examples of fair use that exists. The second thing judges are going to look at in determining if something constitutes fair use is the nature of the work itself. The more fictitious or the more fictional the work, the more it will be protected by copyright. Fact-based, documentary-style biography type things benefit from much less protection because they are actually just fact-based. Whereas highly fictionalized things like Harry Potter, Despicable Me, those types of creations are far more original than the biography of President Abraham Lincoln, for example. The third factor in determining whether or not something qualifies as fair use is how much of the original work is used in the fair use reproduction. Generally speaking, you have to use the smallest amount possible in order to get your point across if it's going to qualify as fair use. For example, playing the entire Nicki Minaj Fefe song so that you can post a reaction video to it is not going to constitute fair use because you could have gotten away with using a much smaller portion of the video than using the entire video. Playing The Room beginning to end so that you can then comment on it is not fair use, but playing very short sections so that you can then react and get your point across could qualify as fair use. Yes, yes. Ouch, we can't, we're gonna cross the street. Let's go. haunting the human sea. Oh my goodness. Hello. And within the consideration of how much of the original work you are using, you have quantitative substantiality, which is how many minutes of the video are you actually showing, versus qualitative substantiality, as in you might be showing only 5 or 10 seconds, but are you showing the most important defining 5 or 10 seconds? Like, for example, doing a review of Fight Club and using some clips for your review versus playing the 15 or 20 seconds when you realize that Ed Norton and Brad Pitt have been the same person throughout the entire movie. Yes? Sorry, spoiler alert. And the fourth consideration that the courts apply is what is the impact on the copyright owner of the fair use? Yes?
Dad.
What do you want to watch?
Daddy fish.
Yes. I have to turn the volume down though, okay?
Why?
Because I'm shooting a video right now. Alright, so the fourth consideration is what is the impact on the copyright holder. If the use is generating more traffic and awareness to the copyright holder, it will be more likely to be considered fair use. If it's driving traffic away or siphoning off viewership, it's not going to be deemed to be called fair use. And this is where the credit comes into play. People are going to say, I'll give you credit for use of your video, as though that's somehow going to drive traffic towards your copyrighted work. When in reality on the internet, 99% of the time it just deprives you of the revenue and drives traffic away from you. And this is where top 10 compilations get into trouble. This is where PewDiePie gets into trouble with his You Laugh, You Lose video. Because a lot of the times he's using the entire clip. So there is actually no beneficial effect to the copyright owner from the use that is being passed off as fair use. It's actually just unfair use. The reviewer or the montage or the top 10er is getting the traffic that belongs to the copyright owner without any sort of spill off or exponentially good effects for the actual copyright owner. Whereas when PewDiePie does a book review or a video review, it is guaranteed driving brand awareness and driving interest towards the copyrighted work that he is reviewing.
Daddy.
Oh, I fell in the water in that one, eh?
Yeah. Five. Water.
Getting back to the most amazing top 10, this guy used a photograph that didn't belong to him without paying the copyright owner for the commercial use of the photo. Giving him credit does absolutely nothing to compensate him for having created the work. It does nothing to generate revenue from his original creation. In life, people are entitled to get paid for the work that they do, and they're entitled to get fair pay for the work that they do. Nobody works for free, and nobody becomes someone else's involuntary donor. There's a fifth consideration we'll get into after we watch this magnificent video of me catching a pike and saving a bee. High five.
More fish.
More fish? For those of you who have never seen this video, go check out the video of me drone bass fishing. I caught a 3.5 pound smallmouth bass off my drone, floating a jitterbug, trolling it on Lake Champlain in Canada. Okay, we're gonna get to the fifth consideration right now. And the fifth, how can I say no to that thing? And the fifth and final consideration that the courts will factor in determining if something constitutes fair use is going to be any other factor they consider relevant, which is sort of like the carte blanche to determine fair use on a case-by-case basis. The courts, at least in the US, basically come to the do unto others principle. In determining if something is fair use, think about how you would feel if you were in the copyright holder's shoes facing someone who did what you did, claiming fair use. If you would feel as though it's unfair use, it probably is unfair use. I don't know who that was. All right, and one thing that I forgot to mention, sanctions. What are the sanctions for copyright infringement? Depending on the jurisdiction, sanctions can be profits lost, profits gained by the infringer. You can elect for statutory damages, which are just damages provided for by law without having to actually prove any actual damages. Other sanctions, confiscation of the copyrighted work, because the idea is that if you made a copy without being entitled to it, it's the copyright owner's copy, so you can go in and seize all of the copyrighted goods, pamphlets, pictures, videos, CDs. An anecdote from my practice of law, we took an action in copyright infringement against, doesn't matter who, we elected for statutory damages because it was much easier than actually trying to prove real damages. We got statutory damages, we seized all of the copyright infringement goods, and in that case I believe the company ended up going bankrupt, just another one of those cases where in law, even when you win, you lose. But I am anticipating... Are you peeing on camera? I am anticipating that in the absence of a settlement, it's not going to go well for the Most Amazing Top 10 because by all accounts there seems to be some outright copyright infringement, unauthorized, and it seems that some of the after-the-fact action or conduct might have exacerbated the initial wrongful act. I hope you have found this vlog informative and educational. What are you eating? What are you eating? Peace out. Boom!